Nobody really understands the First Amendment, or at least that's the narrative of our times. The political right scoffs at campus radicals who regularly shut down conservative speakers. The political left complained bitterly about President Trump's frequent attacks on the media and his repeated promise to take another look at libel laws. And despite the frequent social media blow-ups over First Amendment issues, a shockingly high number of Americans are ignorant of the First Amendment altogether. According to a survey conducted by the Annenberg Public Policy Center in 2017, more than one-third of American adults could not name a single right in the First Amendment. But I'm skeptical of this narrative. Americans live the First Amendment every day. Artists, whether painters, photographers, or rap musicians, produce and publish their works on a plethora of media, largely without fear that they will be condemned by a council of clerics or some other guardian of public morals. The news media is now dominated by pundits who make cushy livings by voicing outrageous opinions, all without the fear of some government thug knocking on their door. We also have a remarkably tolerant religious society, especially by historical standards. All of this is proof that Americans have internalized a great deal of the principle of the First Amendment and have made it a part of our collective culture. So why does the narrative persist? One reason is that most Americans assume that the First Amendment means only legal rules and doctrines. And I believe this is largely because lawyers repeatedly tell anyone who will listen that no one really understands these cases and rules because nobody but lawyers can understand these rules. Lawyers have a professional motivation for saying this, and the end result is a kind of victory by definition. Most Americans, not being lawyers themselves, are told that they cannot possibly understand the Constitution. I disagree. This is the first of several lectures that will lead off our historical examination of the First Amendment. But rather than start at the beginning, we are going to start at the end. We are going to look at how the modern First Amendment operates, how the Supreme Court has handled it in the past half-century. This will, hopefully, have the effect of making the cases less scary by making them more familiar. But it will do something else as well. Once we become familiar with how First Amendment law is constructed today, we will be in a position to see just how differently it was conceived and how it has been handled throughout American history. Let's start with the text. The First Amendment is actually made up of several different clauses. An Establishment Clause, the Free Exercise Clause, both of which have to do with religion, and then the Speech and Press Clauses, and then also the Assembly Clause and the Petition Clause. Now, how shall we look at this text? If we extract the speech portion, we are left with this: Congress shall make no law abridging the freedom of speech or of the press. So what does this mean? Does this mean that only Congress can be restrained from making a law that abridges such freedoms? Well, what about the state governments? And does it mean, literally, that Congress can pass no law governing speech? Well, what about regulations governing commercial speech? Truth in advertising, for instance. I mean, nobody under federal law can actually claim a First Amendment right to peddle cigarettes as a cure for lung cancer. So let's start with this first of these two questions. The First Amendment's text might read that Congress shall make no law, but it is actually interpreted today to mean that Congress and the states shall make no law. How's that? The answer is incorporation. Not corporations like Walmart or ExxonMobil or pass-through companies, but incorporation, a process by which rights listed in the first 9 amendments to the Constitution were made into general rights, enforceable against the states. The story of incorporation is both complicated and actually a little bit easier than people understand. The story goes something like this. It was unclear whether the Bill of Rights bound the federal government or announced a broader set of principles meant to constrain both the federal and the state governments. And the clear distinction here is with the Bill of Rights that it is quite possible, and a lot of people probably did think, that they were enunciating general rights that Americans held. And if they were doing so, then there was a sense that anybody could appeal to the rights in the Bill of Rights. And certainly, people began doing this. But it's not until 1833 that the issue comes before the Supreme Court of the United States in the case of Barron v. Baltimore. According to Chief Justice John Marshall, the question of whether the Bill of Rights applied to the states was not a hard question. He began with a logical premise. The Constitution was ordained and established by the people of the United States for themselves, for their own government, and not for the government of the individual states. If you accept this premise, it followed that the amendments constrained the federal government, but not the states. Besides, noted John Marshall, the state governments had their own constitutions and their own Declaration of Rights. They had other places to apply for relief, particularly when the state governments were actually threatening them. So, in 1833, the Supreme Court of the United States had declared the Bill of Rights to apply only to the federal government. At this time, Congress shall make no law meant only that Congress shall make no law. 30 years and one civil war later, matters changed. 3 new amendments remade the United States Constitution. The 13th abolished slavery and the 15th established voting rights, but in between the two was the 14th Amendment. The 14th Amendment remade the Constitution. It created universal citizenship. In 3 clauses, it restricted the powers of the states. States were prohibited from abridging the privileges or immunities of citizens of the United States, of depriving any person of life, liberty, or property without due process of law, nor denying to any person the equal protection of the laws. There were many who helped write, pass, and ratify the 14th Amendment who believed that it made the Bill of Rights enforceable against the states. Even when they believed they were not being that specific, they understood that the old states' rights regimes of the 1830s was over. The Civil War amendments shifted the balance of power from the states to the federal government, creating new sources of federal power and restraining the states in a way that would have been unthinkable back in the age of Andrew Jackson. Regardless, almost a century would pass before the Supreme Court started taking seriously the idea that the Bill of Rights could be enforced against the states. Beginning in 1925, the Supreme Court began enforcing rights found in the Bill of Rights against the states. They did not do it all at once, nor in any coherent manner. The legal rationale went something like this. The freedoms guaranteed by the First Amendment are substantive rights. Substantive rights in this case just means a tangible right, such as organizing politically or the right to speak freely. In other words, the First Amendment is part of these substantive rights, but they went beyond the First Amendment, and they might include things that aren't actually enumerated within the Bill of Rights. Regardless, all of these rights that are located in the First Amendment are in fact substantive rights. And such substantive rights are liberties that cannot be taken away except by due process of law. And that brings us to the third peg here. In 1925, through the Due Process Clause of the Constitution of the United States, the Bill of Rights is incorporated into the Constitution. The first case where we see this is Gitlow versus New York in 1925. If all of this has you confused, let's try a little recap. In 1833, the Bill of Rights was held by the Supreme Court to not apply to the states. The Supreme Court declared very firmly that because it was a federal constitution matter, it could only be applied to the federal government. In 1868, the 14th Amendment restricted the state's power in several clauses. Beginning in 1925, the Supreme Court began incorporating the Bill of Rights into the Due Process Clause of the 14th Amendment. The result was that no state could deprive any person of their First Amendment rights. This is incorporation. Once you understand this, you understand how the First Amendment became everybody's rights in America, enforceable against any government at any time. First Amendment jurisprudence is really, really messy. In part, this is the justices' fault, as they employ different styles of interpreting the Constitution when they write the cases that make up the First Amendment. But another reason it is messy is that there are a whole mess of different standards that the justices use to treat different laws. Justices use one standard for content regulations and another for conduct regulations. They use one test for establishment and another for free exercise. Some laws they look at strictly, others they look at on a rational basis. They have the Lemon test, they have the Spence test, they have the O'Brien test, they have many tests that they employ. Why is this? We have to start with understanding that all of this is new. Up until the 1930s, the Supreme Court had applied largely one standard of review to legislation to test its constitutionality. A law was either constitutional or it was not. The court had also used its power primarily to invalidate laws that violated economic rights. Using its power of judicial review, the court had declared invalid labor laws, ones that had regulated maximum hours of labor for a work week or had guaranteed a minimum wage. During the Great Depression of the 1930s, the Supreme Court became notorious for striking down New Deal programs, like the Agricultural Adjustment Act and the National Industrial Recovery Act. They struck them down as unconstitutional. The result was a constitutional crisis. We have to remember, of course, that this was the Great Depression. And during the Great Depression, the fact that the Supreme Court was tying the hands of the government meant that the Supreme Court would face a great reckoning. And certainly we see this. Not only did Franklin Delano Roosevelt denounce the court, but so did vast majorities of the people. And in the election of 1936, anger against the Supreme Court resulted in huge Democratic Party majorities. Franklin Delano Roosevelt himself announced a court-packing plan that would stack the courts with Democrats. His plan did not succeed, but the Supreme Court did begin to rethink its consistent invalidation of labor regulations and administrative programs. But this also came at the same time that the Supreme Court was starting to enforce the Bill of Rights against the states. So if we look back at this timeline again, what we have is, on the one hand, two different periods of review, but most importantly, this period after the Civil War leading into the Great Depression, when the Supreme Court began invalidating federal and state laws, and when they did so on the basis of protecting economic rights. When this came into conflict with the political institutions of Congress and the President during the 1930s, we get taken into a period of crisis. And here is, of course, precisely the point where the Supreme Court began to invalidate laws that violated fundamental rights. So what was the Supreme Court to do? The Supreme Court announced a solution in a footnote to one of its decisions. That's right, a footnote. It was a 1938 case called Caroline Products versus the United States, a case about interstate commerce regulations. The Supreme Court had just announced that it would not question the legislature about what it determined was interstate commerce. And this is very important. In other words, when you read this decision, they were saying very clearly, look, if there's a rational basis for the legislation, we won't look at it too strictly. But then the court added a footnote. In footnote 4, the court announced that there may be narrower scope for operation of the presumption of constitutionality when legislation appears on its face to be within a specific prohibition of the Constitution, such as those of the first 10 amendments, which are deemed equally specific when held to be embraced within the 14th. In other words, the Supreme Court was staking out brand new territory. And this territory would separate the review of economic legislation from the review of legislation that touched on specific enumerated constitutional rights. So subjects like interstate commerce would be the dominion of Congress. The court there would not pronounce any of those laws unconstitutional if those laws rested upon some rational basis within the knowledge of and experience of the legislators. However, if a law touched on the Bill of Rights, then there would be a narrower scope of operation for the presumption of constitutionality of the law. In other words, they would apply a stricter standard to any laws that touched on rights enumerated in the Bill of Rights. Laws that were specifically enumerated to belong to Congress would receive not so strict of a scrutiny. This is what historians have called bifurcated review. In short, it means that the Supreme Court would scrutinize some legislation more strictly than other legislation. Put another way, if laws impinged on certain rights, then they would receive stronger and stronger judicial scrutiny. And there was no playbook for this, by the way, no instruction manual, and the Supreme Court was literally making it up in 1938. They would ultimately come up with a number of different tests and levels of scrutiny. Here's the basis of them, the idea of strict scrutiny, intermediate scrutiny, rational basis. Another idea of rational basis with bite, which suggests a slightly higher standard than rational basis. All of it, of course, getting at the idea that the Supreme Court could have a muscular period of review, a muscular area of review, at the same time that it practiced judicial deference. Now, we'll come back to this later in the lecture, but just understand that there's kind of rational basis and everything else. Rational basis was the least form of review, and there was a tremendous amount of deference to the judgment of the legislature in any area that was subject to rational basis review. A heightened scrutiny, which ultimately will morph into a number of different standards. This is strict scrutiny, intermediate scrutiny, or even rational basis with bite. All of these different ones are forms of heightened scrutiny. But again, we have to remember that the period of bifurcated review is a brand new one. It is not part of the constitutional text. It was not a part of judging in the early republic, or certainly in the founding era. It is one that is invented for modern jurisprudence. And it is invented because, in large part, there was no way under a unitary standard of review for the Supreme Court to continue a muscular defense of rights and liberties while it was also being deferential to the legislature. To recap, bifurcated review was new and would ultimately lead to various other standards of review. At the low end of the spectrum was rational basis. This was the standard that was the most deferential to the legislature. Laws that touched the First Amendment speech and press clauses would be subject to stricter scrutiny. The highest standard was strict scrutiny, and it applied largely to content regulations. It would come to mean several things. First, all laws that govern the content of speech were presumptively unconstitutional. Second, the law had to be related to a compelling government interest. Third, laws had to be narrowly tailored. This meant that they had to be the least restrictive means possible to achieve the desired result. Laws that regulated conduct were generally subject to intermediate scrutiny. These laws were not presumptively unconstitutional. They only had to be related to a substantial government interest. One thing that you should have gathered by now is that the First Amendment operates against the government. Thanks to incorporation, it protects you against the federal government or the state government. But this is a doctrine of state action. What it means for our purposes is that you cannot expect the First Amendment as a shield if somebody injures you in a private manner. So what we have here then with the doctrine of state action is that it has to be Congress and the states that ultimately are depriving you of your First Amendment rights. That is the doctrine of state action. Now, within the doctrine of state action, we have to understand that there are two different sources of authority for Congress and the states. The states operate actually with more authority than the federal government because they have the power of police. Now, in this formulation, police is not some guy with a club and a gun or the person who pulls you over for speeding. Police means the general reserved power of the state to regulate the health, safety, welfare, and morals of the citizenry. That's right, the health, welfare, and morals. These are legitimate areas of state regulation, and it is what has allowed states traditionally to ban pornography, to compel you to get a driver's license, to pass zoning regulations, and so on. The power of police is broad, deep, and reserved to the states. The only extent to which it can be controlled is when it is specifically limited by either a state constitution or the United States Constitution. The federal government has no power of police. Actually, this isn't true. There's certain areas of police that it does have, but we'll just take that as a given now. They certainly have no general power of police. What the federal government does have is enumerated powers, such as the power to regulate interstate commerce and to declare war, to establish a post office, etc. Each of these powers could easily impact political speech and writing. Moreover, Article 6 makes federal law supreme over state laws. So to recap, when you are looking at laws that govern speech, there are different sources of power for state and federal law. The state's power comes from a large and deep well, the police power. The federal government's power comes from a smaller well, the powers enumerated in the Constitution. But they do trump state law and state constitutions if the two are ever in conflict, thanks to Article 6, the Supremacy Clause. Congress shall make no law abridging the freedom of speech. What exactly is speech? Going to a dictionary does not help here. We have to come up with a legal interpretation of the clause itself. One of the first steps in giving meaning to the First Amendment is to look at its original meaning. What did free speech mean in 1791? A rudimentary historical search will reveal that protections of free speech did not include conduct regulations, defamation, obscenity, the profane, or blasphemy. There were actually other ones as well that were unconnected to protections of free speech. But in short, the drafters and readers of the First Amendment did not think that all speech was suddenly protected under the First Amendment. They believed likely that a certain kind of speech was being protected. Many of these categories still exist. First of all, we preserve a speech-conduct distinction. Conduct is always subject to much more regulation than content. Defamation is still not protected speech, nor is obscenity, or indecent behavior and speech, or fighting words, or the provocation of imminent lawless behavior. Besides these unprotected categories, there is today a privileging of certain kinds of speech. Political speech is far more important than commercial speech, which is subject to far more regulation. So this raises a question. At what point do legitimate government regulations of behavior and unprotected speech bump up against the First Amendment? For the first 150 years of American history, this was a question argued in Congress, in the press, in state legislatures, and occasionally in federal and district courts. The Supreme Court did not step in until the 1940s to begin genuinely building a First Amendment jurisprudence. The timing is important. First, incorporation had already occurred, meaning that the Supreme Court would consider its jurisprudence as universally binding, thanks to incorporation. Second, the announcement of bifurcated review meant that the Supreme Court could begin inventing much stricter rules for assessing laws that govern speech than it ever had before. The result has been a creative period in American law. The whole creation of a welter of new standards has come from this period of bifurcated review. Each of these standards has a history, and in some cases those histories are still being written and rewritten. Let's start with laws that regulate press freedom. If we are talking about press freedom, then laws governing the press are immediately suspect. If we are talking about the state preventing something from being published ahead of time, we call this prior restraint. Any prior restraint of the press is presumptively unconstitutional. Can one print untruths about someone? Not without consequences. This is libel. The First Amendment jurisprudence has created different libel standards for different kinds of people. If we are talking about private persons, then the standard for proof of libel is quite low. But if we are talking about public persons, like elected officials, then the standard is quite high. To prove a libel in those cases, you have to show not only that the statement is false, but that the publisher published the false statement with malice aforethought and with reckless disregard for consequences. That's a tough evidentiary standard to meet. That's all for press freedom right now. Laws and actions that impede the press receive the highest scrutiny from the judiciary. Let's turn to speech and conduct regulations. In general, laws that raise First Amendment concerns do so for two reasons. Let's turn to speech and conduct regulations. In general, laws that raise First Amendment concerns do so for one of two reasons. Either laws are invalid on their face, that is, the law itself is against the Constitution, or it is unconstitutional as it is applied. And so you will see facial challenges or challenges to the face of the legislation or as applied challenges. There's a couple of examples here that come out of real life that illustrate this quite well. We have the Constitution, and the Constitution guarantees freedom of speech, and that has been held by the Supreme Court to hold symbolic speech as well as actual speech. And then the federal government passes a law which makes it a crime to burn or in some other way physically defile the flag. Now, any action you take with the flag is going to be symbolic action, and in 1989, the Supreme Court in Texas v. Johnson ruled that flag burning statutes were in fact unconstitutional. They violated the First Amendment. So the law goes because on its face it violates the Constitution. In another case, Yickwo v. Hopkins, this is an old case, 1886, a law which, state law in California, which governed laundries, in particular the use of laundries in wooden buildings, was valid on its face, but was used largely to deny people, Chinese people, the right to run laundries. In other words, no Chinese person could get a license. And this was declared to be an unconstitutional violation of the Equal Protection Clause, and as such was struck down. But as you'll note, it wasn't because the law itself was invalid. There's nothing wrong with passing a law regulating laundries, particularly when you have a public safety problem, wooden buildings, flames, etc. The problem was the way it was applied made it a violation of the law. So we have either facial challenges or we have as applied challenges. Laws that govern speech are typically divided into two categories: content regulations and conduct regulations. Content regulations of speech are presumptively unconstitutional. In the language of bifurcated review, the highest standard of review is used: strict scrutiny. Now, strict scrutiny means different things in different areas of jurisprudence. It doesn't have a single meaning. When it is used in speech content cases, it generally means that regulations must serve a compelling government interest. This is distinguished from a substantial government interest, the standard for immediate scrutiny, or rational basis, where they simply defer to the legislature. It doesn't have any independent meaning, this idea of a compelling government interest. It is just meant to be distinguished from the very squishy and deferential rational basis versus a substantial basis. Strict scrutiny also requires that the law be narrowly tailored to achieve its result. Over time, this came to add a burden of proof on the government, requiring it to show that there was no less restrictive means available to effect the end it desired. If the restriction was legitimate, then this would be allowed. The narrow tailoring requirement leads to a couple of obvious ways courts might find legislation unconstitutional. Laws might be struck down for being overbroad. Now, it's a weird word, overbreadth, which is the doctrine. Laws are overbroad when they reach out to touch protected speech. So even if the law regulates some unprotected area of speech, it might be unconstitutional if it breathes onto some protected area. Now, to be clear here, it can't just be a single breath. It has to be a substantial breath. So the doctrine is actually known as substantial overbreadth, and it has to touch on a lot of protected speech in order to be used. A related way that laws might be facially unconstitutional is if they are vague. In a way, vagueness sounds a lot like overbreadth. If a statute is vague, after all, it will touch a lot of protected speech. But the difference is the standard. A vague law is one that reasonable people will interpret in substantially different ways. To put it another way, a vague law does not make it clear exactly what it is prohibiting. Both overbroad statutes and vague statutes can be found unconstitutional because they have a chilling effect on constitutionally protected speech. Let's look at some examples from areas of unprotected speech. Let's start with calls to imminent lawless behavior. This has a delicious history, and we will deal with this history this semester, but note this. The law that governments have the ability to squelch speech that threatens imminent lawlessness has at least a foot in the old doctrine that any criticism of the ruler, whether a king or a government or a priest or an elder or a father or whoever happens to be in charge, is not allowed. It doesn't matter if the criticism is true or not, it is not allowed. It is most often punished by death, and you can find warrant for this in Hebrew law, canon law, Roman law, and the common law. Now, in the English common law, the crime was called seditious libel. In both England and the English colonies, seditious libel was a crime and was punishable. Various bills of rights passed by states and ratified in the form of the First Amendment challenged the law of seditious libel, but it was not enough to prevent sedition laws from being passed by both the states and the federal government. In 1917, Congress passed a Sedition Act to aid the government's efforts to enter World War I. In 1919, the Supreme Court declared in Schenck that this law was constitutional. There was, they said, a clear and present danger that the government could protect the people against. This standard lasted for about 50 years before being thrown out altogether, although during this time it was chipped away at. But finally, in 1969, in Brandenburg v. Ohio, the Supreme Court dispensed with the clear and present danger test virtually altogether. Notice here, though, that in this there is a trajectory away from authority and toward liberty. Another area of unprotected speech is fighting words. They are unprotected, and they are still unprotected today. But importantly, the judicial test for deciding what constitutes fighting words has been significantly tightened from the 1940s until today. In order for the state to silence a speaker based on this principle, it must now be words that are directed specifically to a person that are likely to provoke an immediate and a violent reaction. Obscenity is also not protected, but here First Amendment jurisprudence is a lot more confused than in other areas. The standards have moved up and down and have never been clear. Anyone who takes a long look at American culture, whether popular culture or high art culture, should be able to see the problem with defining obscenity in any reasonable way. Let's turn to conduct regulations. Here the government has far more latitude to regulate than it does in content regulations, and the welter of judicial tests used under conduct regulations reveals this. There are two primary ways that conduct regulations affect speech in assembly. One way is through a general law that incidentally regulates a speech act. Let's take an example. David O'Brien opposed the Vietnam War and opposed being drafted for the Vietnam War. On the morning of March 31, 1966, he went to the steps of the South Boston courthouse and publicly burned his draft card. Federal officers were there and arrested O'Brien under a federal statute that made it a crime to mutilate or otherwise damage a draft card. He claimed that his burning of the draft card was itself a speech act. He meant to communicate his anti-war position. As such, he said, this symbolic speech was protected by the First Amendment. Now again, in 1966, the Supreme Court protected symbolic speech. 30 years later, they would invalidate the Texas statute that made it a crime to burn the flag on the grounds that that was expressive, symbolic speech. But in 1968, Chief Justice Earl Warren led an 8-1 court in upholding federal law. O'Brien, he said, might have been communicating a message, but this did not mean that his expressive symbolic act was necessarily protected. The government's regulation, after all, had not been a speech regulation. It was a regulation about government property, and the government had a substantial interest in protecting that property. What was more, the regulation never attempted to suppress free expression. It was narrowly tailored to achieve its ends, and it did not burden freedom of expression any more than was needed to protect the draft cards themselves. So, if government regulations that do not directly regulate speech end up interfering with it, a slightly less strict standard is used to test them. In this way, the government's normal operations are not subjected to constant scrutiny. And you should note here that that difference between a conduct and a content regulation is very important. It's only through the secondary effects of the legislation that you have some sort of intrusion into the content of speech. Some conduct regulation directly relates to speech in assembly. These are time, place, and manner restrictions. They include, for instance, the need to obtain a permit if you are planning a march or a public gathering. The government might reasonably require all assemblies to take place during daylight hours in the downtown area. This regulates the time of events. The government might also tell you that you can assemble in the park, but not on the highway. This would be a place restriction. They might also require different permits for different sizes of events. This would be a manner restriction. So, time, place, and manner restrictions. For a time, place, and manner restriction to be constitutional, there were several things that it had to meet. First of all, it had to be viewpoint neutral. That is, it could not favor one viewpoint over another. It had to be narrowly tailored to achieve the end, and if it made things difficult for people, there had to be an availability of alternative venues for people to express their constitutionally protected speech. That about sums it up. The doctrines that govern the First Amendment have been articulated, disarticulated, put forward, contested, challenged, and vaguely settled upon over the past 80 years. They say something about the way in which we define the First Amendment, and they are quite important. But they are not the only measure of free speech in this country, nor are they even a good measure of the quality of our free speech, political, artistic, or otherwise, in this country. But because court doctrines are infused with power, because they regulate how power might operate in our lives, it is important to have a rudimentary grasp on them before we explore their evolution and their limits.